Yes, as they were running to the elevator. Here, have some more discovery. They gave us 2 reports just that way yesterday.
That's not correct, Your Honor.
Well,
Wait your turn, Mr. Douglas.
we'll get there. Mr. Darden, all right, what is the date on this witness statement?
Do you have it here? I believe it is, well, why don't the court inquire Mr. Douglas, if you don't mind? I don't have it immediately available.
Okay. So but you have now a statement from Mr. Bucola
Yes,
regarding that incident?
yes.
All right.
I believe it's dated, you would inquire?
No, I'll find out soon enough.
Okay, well, it's about January 25 or something like that.
Okay.
And it raises a significant issue, I think. As we proceeded with our investigation, we interviewed witnesses on January 1, and January 2, and January 3, and dates like that, and January 10. And as we turned those witnesses over to the defense within 1 business day, and in compliance with the court's order, we were nevertheless precluded from mentioning those witnesses in opening statement. And we were precluded from calling those witnesses until the end of the prosecution's case. And it was no fault of ours that we discovered these witnesses on January 1 and turned them over the next day. It was no fault of ours. And still, we had to suffer some form of sanction. We suffered a sanction for being diligent. They've given us this gentleman's statement taken just a few days ago. He should move to the back, just like ours.
Now, I don't recall this person being mentioned in opening statement or any issue.
Okay, then he should just be required to move to the back then. And Mr. Cochran should be precluded from mentioning him in the event he intends to.
Certainly. Madam Reporter, how are you doing? All right, I'm going to go another 15.
We received a number of statements on January 25, Your Honor. Mr. Bacola's statement was one. We received a statement regarding Mr. Jason Wood, and we will seek no sanction as it relates to Jason Wood. We interviewed him, we're acquainted with him, and the report we received was consistent with what we already know. And so we will seek no sanction, but we will ask the court, however, to ask the defense, do they have information in addition?
Thank you.
Next, Your Honor, there's Ronald Taylor. We received his statement on January 25th. He was on their August 31 witness list. However, they waited until January 25th to give us a statement. There was Paul Solenshine, S-O-L-E-N-S-H-I-N-E.
Hold on. All right, Paul Sunshine, the Rubens employee.
Your Honor, I stand corrected. We did receive an earlier statement on Taylor. Don't talk to me, okay? We did not receive a statement on Paul Solenshine until January 25. As I indicated, he was on the August 31 witness list. However, no statement was provided. The same applies to Rosita Ruban, R-H-E-U-B-A-N. We require time to investigate the content of their statements and determine if they have information relevant to these proceedings. They should not be allowed to call these witnesses.
Are the people intending on presenting any of the items seized from Mr. Cowling's automobile?
We have not yet made that decision, Your Honor. They should be precluded from calling Mr. Solenshine and Ms. Ruban until the conclusion of their case and until we have been given a reasonable opportunity to investigate their backgrounds and the content of any statement they might give. Next, there is the statement of Tony Parker given to us on January 25. We had no prior discovery regarding this witness. We require additional time to investigate the content of his statement as well as his background. We were given a statement, or rather Kevin Whalen's statement, and he claimed to have gotten the defendant's autograph on June 12, 1994 at 11:20. You would think that he might be a material witness to the defense, and I'm sure they saw it that way. And he was on their August 31 witness list, but they didn't turn that statement over to us until January 25th, 6 months after the homicides. Yesterday, Mr. Cochran mentioned, strike that. On the January 25, we received a statement from Narendran Singh regarding the possibility of a tape of some kind at the Mezzaluna restaurant. This person was on the August 31 witness list. We received that person's statement on January 25, 1995. And next is Alex Castillo. He has some information regarding a beeper, a pager. And he was on the defense August 31 witness list. But it was not until January 25, 1995 that we received a statement or a report. Can I have one moment, John?
Certainly.
Time and time again, the prosecution stood before the court advised the court that the defense was playing fast and loose with the discovery rules, with the evidence. Each time, a member of the Dream Team stepped to the podium and advised the court to what they thought the law required. They advised the court that they had no discovery, they had no reports, or they didn't intend to call a witness, or that they had no duty to turn over relevant and material information, statements from material witnesses that they knew from day one they would want to call in this trial. And they did that time and time again. Mr. Douglas did it just last week on January 20. The court may recall, and this is at volume 73, at page 11319, where Mr. Douglas informed the court, "Certainly, Your Honor, the court understands our obligations under the Discovery Act And certainly, Your Honor, with this fine collection of lawyers, we understand our obligations under the Discovery Act. And I think their understanding, Your Honor, was probably correct, and that is that they had a duty to turn over the statements of these material witnesses. And I think they understood that. I think the law is pretty clear there. I think Mr. Ullman stated it rather succinctly and clearly when he said, in circumstances like these where trial has already begun, each party has a duty to turn over to the other party discoverable material immediately. And Mr. Ullman said to the court, Your Honor, immediate means immediate. It means now. It means soon as possible. And that, as I recall, was the court's understanding of the term. Well, we've been in trial since September, as I understand it. Well, it is that section of the discovery rules that applies to these defendants, to this defendant and these defense attorneys. They should have turned over this information to us immediately. But they didn't. They wanted to sandbag us. Had they turned the information over to us last week or at Christmas or on December 14, as we did, the court will recall that on December 14 we turned over discovery to the defense and you had to pull them off the ceiling. It's 6 weeks later now. The sanctions the court imposed on us back on December 23rd and earlier are still in effect. They've had 6 weeks to conduct an investigation, and in that 6 weeks, I don't know what they did in terms of an investigation, but in that 6 weeks, they certainly had an opportunity to think about the issue of discovery. I mean, they filed a 40-page brief on the subject. They argued it to the court day after day. They understand the law. They understand the rules. They know that they are not allowed to turn over discovery to us after Mr. Cochran has mentioned the content of that discovery before the jury already. They know that they have a duty to turn over information to us immediately. But they didn't do that. They didn't do it last year. They didn't do it last month. They didn't even do it the morning before Mr. Cochran began his opening statement. And that's outrageous. That's outrageous. And they didn't do it because they knew that had they done it, you would not have allowed Mr. Cochran to poison the minds of these jurors with hearsay on top of hearsay, with the content of statements given him by witnesses who are completely unreliable, and whose background I am sure that if Mr. Cochran knew or was aware, he would not have even mentioned. When the voters in this state passed Proposition 115, there was a clear mandate, and that mandate was no more sandbagging, no more sleazy trial tactics, no more abuse of the process or of the system or of the courts. As the court already alluded to earlier, discovery became a two-way street. I don't know why the Dream Team can't seem to understand that or grasp that, or why they don't want to follow the rules. I understand that they have a celebrity client, and I understand this is allegedly the biggest murder case ever, but the rules don't stop just for this case. The rules apply to this case. Had we done what they did, I shudder to think what the court would have done to our case. Because even despite our innocent and negligent mistakes in terms of discovery, you've gutted our case to some extent. You've dismantled it in many respects.
Rearranged it.
You rearranged it all right. And I don't think that's fair. But the bell has already been rung, Your Honor, and the shot has already been fired. And once the shot's fired, as Mr. DeBlanc stated last night on television, once the bullet's out the gun, you can't get it back.
You had time to watch television last night?
I heard about it. I heard about it, Your Honor. I've missed the entire NBA season up to this point, and I am upset about that. But the people have a right to a fair trial just like Mr. Simpson does. And we have a right to play on a level field. And that field is supposed to be level and supposed to be balanced. Well, there is a terrible imbalance now. And this imbalance is brought about by the Dream Team's refusal. There's intentional and willful disregard of some very basic and fundamental rules of discovery. This is their fault that the field is no longer a level playing field. It's their fault that things are out of balance. And I want the court to understand that it's not, so much of Mr. Cochran's opening statement the other day. I mean, he did what I figured he would do. He's a good lawyer. They say he's the best. He's a friend of mine. I'm proud to have him as a friend of mine, but I'm disappointed in him. But I want Mr. Cochran to know, and Mr. Simpson too, to know that we're not just here playing games either. We may just be civil servants and blue-collar lawyers, Your Honor, but we intend to win this case. But the only way we're going to win, and the only way we can fully and fairly participate in this process, would be if the court rectified this imbalance. And I believe the court must, because this problem and this issue, it's more than just an affront to the prosecution. It is an attack on the integrity of this court. They violated your rules, not just mine, not just the legislature's, not just the rules of court, but your rules, Your Honor.
The legislature had nothing to do with this, Mr. Darden. Do you know that?
Thanks for pointing that out to me, Your Honor. We would ask that the court admonish the jury, and we would ask as well that we be granted a brief continuance so that we can fully assess what has happened, so that we can investigate the backgrounds and the information provided to us in court these past couple of days. And we think we have a right to that. I think we have an absolute right to that. The code section speaks to the remedies the court can provide in a situation like this, where there exists such a flagrant violation of the code. And we would ask that the court allow us to reopen our opening statement. And to correct the imbalance, to make the playing field level again. I'm sure Mr. Simpson didn't play on lopsided playing fields back when he was in the NFL, I mean, there were 11 guys on each side. It was fair. Of course, they had Mr. Simpson on their team. I just want a fair shot. We just want a fair trial. This ain't all about just winning and losing. It's about fairness. It's about justice. Starting to sound like Cochran, aren't I? Although there is little case law, no case law on the issue of reopening an opening statement, there is case law addressing the issue of reopening closing arguments.
I'm familiar with those cases. I was looking for one that dealt with opening statements.
So was I, and I was looking for that case until 2:15 this morning, Your Honor.
I know all about reopening argument, Counsel.
And I would say this as well.
Let me rephrase that. Okay. I know something about it.
And I know the court knows that the court has discretion in terms of the order of proof, in terms of the order of the processes here in this case. And I would say something else, Your Honor, about what has happened here. We have something in the state of California called the Rules of Professional Conduct. It's ethics. And I'm not here to accuse my distinguished colleagues of being unethical. But I would like to point out, if I may, to the court, that there exists in the State Bar Rules of Professional Conduct, Section 5220, entitled Suppression of Evidence. And that section indicates that a member of the bar shall not suppress evidence, that the member or the member's client has a legal obligation to reveal or to produce. And there's also Section 5-200, subsection B, which states that members of the bar shall not seek to mislead the judge or the trier of fact What has happened here over these past months has been misleading. We've been misled. I believe the court has been misled. There's a clear indication that they have suppressed evidence, information that they should have turned over to the prosecution. And I'm not saying, hey, you should call the state bar or something like that. I'm not saying that. These are my friends. But I do think that they have committed a flagrant violation of the discovery rules, and they have caused the people to suffer extreme prejudice. How are you going to unring the bell? How are you going to get back the bullet once it's already fired? They brought this on themselves. We didn't do it to them. We'd like a fair trial, a fair shot at presenting to this jury the truth. We're not getting that. And we won't get it as long as they are allowed to play fast and loose with the rules. May I have one moment?
Mr. Darden, maybe this would be an appropriate time to take a court reporter recess. All right, we'll take 15. Mr. Darden, do you wish to conclude your comments?
Yes, Your Honor.
No, you had gone through
Yes. I have a
number of items.
Yes.
Do you have any other specific items? And I want to thank you for the specificity of your comments to the court.
Thank you, Your Honor. I just have a few brief comments, if I may. We would just like the court to know that we feel that we have a right, and we feel our position is supported by the law, but we feel that we have a right to preclude the testimony of some of the witnesses whose statements were given to us just recently, or whose statements haven't been given to us, but whose testimony was mentioned in front of this jury. And we're not asking for preclusion. And we're not asking for preclusion because we want to see the truth. We want the truth to come out in this trial. We could ask for contempt. We could ask the court to hold the defense in contempt, but we're not asking that. We're not asking that at all. We're not asking to report anybody to the bar. We're not doing any of that. All we're doing here today is asking the court to level the playing field. Now, just before I left out of here for the break, Mr. Bailey mentioned to me that perhaps what I really want is a mistrial. I don't want a mistrial. I like the 12 jurors we have. I like our case. I like our chances. We don't want a mistrial, Your Honor. We want to see the truth. We'd like to see these proceedings continue. And my distinguished colleague, Mr. Bailey, also asked me before we broke if I felt the need to run away. And I want Mr. Bailey to understand that I'm not going anywhere. We're not going anywhere. We're in search of the truth, and we're going to find it. We have found it. We want the jury to find it. We're going to stay right here, Mr. Bailey. We're going to finish this trial. We just need a little time to repair some of the harm caused by the misconduct of your colleagues and yourself. We just want a fair shot at it, John. Nothing more.
All right, Mr. Darden, let me ask you this. One of the remedies that you're asking for is for the court to advise the jury that I am striking from the record Mr. Cochran's comments concerning certain witnesses with regards to certain issues. Then you were also asking for the opportunity to reopen. Are those in the alternative or in the conjunctive?
In the conjunctive.
Because it doesn't seem to make sense if I'm going to strike it and then you come back and talk about it. That sort of defeating the purpose seems to me to be mildly illogical. They seem to be in conflict. Just an observation. Excuse me, counsel, with one.
Well, But
One glad,
we
one,
agreed to the court we were both going to present on this because we just didn't have the time to
Well,
comment to one.
thank you, Ms. Clark. Just an observation. All right, Mr. Darden, have you concluded your comments?
Yes, I have, Your Honor. Thank you.
All right, then I have before me 27 specific items.
If I can indicate, the court may have more. I don't know if the court did a search of the transcript on its own, but that's all that we could pull out in the short time that we had.
Well, I
sure
think 27 is plenty for today.
Okay, we'll get another 27 for tomorrow, Your Honor.
All right, thank you. All right, Mr. Douglas, good afternoon, sir.
Good afternoon, Your Honor. Your Honor, I'd like to begin dealing with some of the discovery concerns raised, and Mr. Cochran would like to deal with some of the sanctioning issues that were raised. Your Honor, at the outset of this trial, the court reminded all counsel that the eyes and the ears of the world would be watching us today. It is my sincere hope, Your Honor, to bring dignity to the profession that I love. So I will not dignify the often vile, insidious, and long-winded comments by my colleague by responding in kind. Your Honor, I've known Christopher Darden for well over 10 years, and he has referred, in fact, to me and to my office, the parents of a young man who was once shot and killed while going home from school. So I cannot fathom that he would have entrusted that family in my care if he believed that I or my colleagues were as dishonest and as unethical as he has inferred. Your Honor, he comes to you seeking equity. He comes to you asking about basic fairness. As the court is aware, there's a concept in equity called clean hands. And that comment says that one cannot seek equity without doing equity in kind. And I submit to the court that before Mr. Darden comes and seeks equity, the true record should be considered so that the court can weigh and properly balance a response given the current state of the full record. Your Honor, in September of 1994, the prosecutors gave the defendants a list of 214 names. On January the 6th of 1995, the prosecutors gave the defendants 207 additional names. 5 more were added the following week. 3 more were added after that. 2 more were added since then. The first of his complaints were based on the thought that the defense had somehow dumped names without addresses or phone numbers on the prosecution, and how unfair that was to the prosecution. I give this court at this time the names of Art Shaftman, Behart Shaw, Joseph Perulli, Eliza Perez, Cindy Patterson, Brett Lobner, Mark Leon, Ray Kildruff, Bo Jackson, Carlos Hernandez, Richard Gonzalez, Don Detzler, Carol DePrima, Jay Swell, Victor Baffa, Nicholas Bolas, Donna Estes, Gary Kawakawa, Amanda Darling, Patricia Foy, David Prestholt, Cruz Priego, R. Wrench, Rodney Shelton, Norman Smith, John Stewart, Mark Stauffer, Jan Von Poppel, Philip Van Saun, Tony Waybright, Christine Wolford, and Charlotte Ward as just some examples of names given to the defense without addresses or phone numbers. That meant, Your Honor, that the defense had to try to find out who these people were, try to locate them, and try to identify them. They were names that were on the people's prosecution list.
All right, Mr. Douglas, if you will, at the conclusion of today's proceedings, give a copy of the list that you just read to the court reporter.
It has been done already, Your Honor. Thank you.
Your Honor, will the court do this as well?
No, Mr. Darden, thank you. I'll hear counsel's argument.
Your Honor, the fact that they don't know who we are talking about when we may obliquely infer that there is a certain witness that might say certain things does not mean that we have committed misconduct. There is no case authority that they can cite, because there is no case to suggest that attorneys have an obligation to create discoverable notes or memos based on conversations with their client or based on conversations with retained experts. Your Honor, the District Attorney's Office has retained many experts to talk about DNA issues, to talk about blood issues, to talk about other issues. But among the 22,000 pages of documents that we've received in this case, there is not one handwritten note from Marcia Clark, from Christopher Darden, from William Hodgman,
Objection, Your Honor.
from Mr. Fairtlow.
He told us he was not interested in our handwritten notes. Specifically, that was an agreement he had with Mr. Hodgman. He is now misrepresenting to the court
Ms.
the
Clark,
agreement.
I'll hear your comments and rebuttal. Thank you. Mr. Douglas.
from Jonathan Fairtlow, from Scott Gordon, from Lydia Bodin, or from any other attorney, Sherry Lewis, Ms. Kahn, or anyone else who has obviously had conversations with other experts. As well, Your Honor, there have been at least 12 DNA experts that have been noticed by both sides. Carrie Mullis, I strongly believe, was one of the names that were included in our list of experts that they are aware of. And I have not received one DNA report from any of these experts based on testimony that they intend to offer in this particular case. So we're talking about fairness, but we must also remember that both sides must have clean hands. The case, Your Honor, began back in June of this year. We have enlisted several attorneys who work out of different offices. At one time or another, we have used 6 different investigators that were involved in different pieces of investigation. They did not always work in concert. They did not always share their work product with each of the other investigators or with each of the other attorneys. One of the items that were turned over yesterday was a witness statement of Mary Ann Gertjes. That witness statement was obtained by an investigator with whom I personally have never spoke. That is an investigator who basically has done limited work on this case, and unbeknownst to me, one of the jobs that he performed was to interview and to obtain a statement of Mary Ann Gertjes. I represent as an officer of this court that the first day that I personally became aware of the existence of his statement, taken of Ms. Gertjes, was moments before I took the podium yesterday when Mr. Cochran gave me a copy, and I asked your clerk to make copies so that I could read myself. Certainly, Your Honor, I recognized fully yesterday that that was a violation to have not turned that statement over. But if the court were to read that statement, the court would see that Ms. Gertjes had contacted the district attorney's office and spoke to Patty Fairbanks in that office. That Ms. Fairbanks told Ms. Gertjes that I'm talking long distance to a psychic, so I'll have to call you back. That in her despair, Ms. Gertjes contacted the police department, giving them information that was brought before the jury yesterday. That Ms. Gertjes' name, address, and telephone number were included on the witness list that we provided in August of 1994. So certainly, Your Honor, while there may have been a problem with our physically turning over her statement, the surprise, the absolute shock and amazement that has been offered here is somewhat overblown. For example, Your Honor, not only did we give the name of Rosa Lopez, we gave her address as being a location directly next door to where Mr. Simpson lived. Not only did we give her name and her address, but we gave her statement as well. Despite having her name, her address, her telephone number, and a statement, there was no representative from either the district attorney's office or the Los Angeles Police Department to interview Rosa Lopez.
She's not one of the individuals under dispute here, Mr.
Your Honor, I'm simply by analogy hoping to offer to the court that the protestations of prejudice are perhaps not in good faith, because though they had the very important information on Rosa Lopez, they never saw fit to go and interview her until Monday evening when Mr. Bailey stood up and explained to this court the significance of her testimony. I offer that to say, Your Honor, that yes, there may have been some facial violations of the code. However, before the court believes that there has been dire prejudice, you have to look at the equity. You have to look at the clean hands. And that's what I seek to offer to the court. Now, Your Honor, there has in fact been a list given yesterday because the court made it very clear on Monday that I would have to go through, on Tuesday. Monday, when I gave the name of supplemental witnesses, I told the court that these were the statements that were attached, and there were, I believe, several names and 6 statements that were attached. There was one name in particular, Scott Matsuda, that the people knew about and that they knew that there had been a statement of, and that statement was not immediately forthcoming because it was not attached in that packet. I then made a call, and the next day that name and that statement was given to the people. It was on Tuesday that the court directed me specifically to go through my entire records and to make sure that I have completely satisfied myself, that I have gone through and found out everything that has not been turned over. And we did an exhaustive process, Your Honor, and we followed through with the court's warnings and the court's directions. And that was how we were able to find out that there were 12 statements that had fallen through the crack. 12 statements out of hundreds of names that were given by the prosecution and hundreds of names that were provided by the defense. Now, Your Honor, of these 12 individuals whom statements have been prepared, there are 5 whom I reasonably expect that I will be offering testimony at trial. Therefore, Your Honor, when the court considers the propriety of a sanction, the court should do so within the context of reality. It doesn't make much justice or fairness to cry out numbers or to call out names without knowing in actuality the impact that it's going to have on this trial. And, Your Honor, it cannot be ignored that this is January the 26th, the start of the beginning of the case. It is a day when typically, in preparation for the trial, the lawyers huddle together, the lawyers review the state of the record, the lawyers review the state of all of the pretrial arguments and rulings, and get together and decide whom we now reasonably expect to call. And we did that. And even on doing that, Your Honor, we omitted the names of Ron Fishman, we omitted the names of Christian Reichardt, and those names will be soon added. But the people have added names just this very week, and we are already beginning their case, should have been today, perhaps tomorrow, but they too are still adding names. Your Honor, when you look at the 5 individuals whom we reasonably believe that we are actually going to call, it is my opinion that only 2 of those names are names that are unknown to the prosecution. And, Your Honor, they talk about how they've been sandbagged. Yet in 24 hours, they have attempted to assassinate the character of Mary Ann Gertjes, one of our witnesses, by suggesting allegations that are totally untrue. And, Your Honor, Mr. Cochran will deal with that more when he comes up. But, Your Honor, there is a tremendously effective wheel that is already in place called the Los Angeles Police Department. And there is another cog in that wheel called the Los Angeles District Attorney's Office. And although they may have been given short time to adequately investigate some of the names, they've done a pretty good job in 24 hours. And I dare say they'll be able to do a much better job in the 2 months' time it's going to take, at a minimum, before we begin calling any witnesses on the defense. Your Honor, if this were the first day of the defendant's case, and we were then intending to call Mary Ann Gertjes or Ron Fishman or Christian Reichardt, I would not be making the same arguments to this court, because I would recognize that there would really be a clear prejudice. But when we have 400 names on a witness list, and when we have a 6-month trial estimate, and when we have the expectation that there will be dozens or scores of witnesses called, I believe this court may fashion a more equitable solution to this problem, a more equitable response to our mistakes, recognizing that these lawyers whom you also know, whom you also have some admiration for and respect for, whom you also believe would not maliciously or in bad faith attempt to sandbag or do all of the things that have been alleged. I think certainly, Your Honor, you don't come into this position in a vacuum, and certainly I think you can understand, given the massive size of this case, given the complexity of issues, given all of the witnesses who will be called, that it is likely that things fall through the cracks. Now, Your Honor, the people stood up here in December and tried to tell you all of the reasons why they made certain mistakes. And the court said that the code required that they immediately disclose and that they hadn't done so immediately. And the court then issued a sanction which the court felt was appropriate. I think the court should do the same sort of balancing today, because in December the 14th, or whenever that hearing was, opening statements were due to begin the following month. We have at least 2 months now before we're even going to call any of the defendant's witnesses. Your Honor, Mary Ann Gertjes is a name, as I suggest, that the district attorney knew of. Her statement taken in July gives the name of Patty Fairbanks or Patty Fair something, clearly suggesting that she had had contact with someone in the district attorney's office. Michelle Abduran, who's another name on our list, with a statement turned over yesterday, is also a person with whom they are aware. They have interviewed other witnesses about Miss Abduran and about the allegations that Nicole Brown Simpson struck her prior to her leaving the Simpson home. Joel Pitkoff, who was an employee of Ford, is a witness who we intend to call, who is probably unknown through the prosecution. And on that one, I would accept the sanction of allowing them to adequately provide or perform background investigation and background research and try to challenge the strength of the numbers that he is going to offer and require us to wait and receive permission from this court before we mention his name or before we call Mr. Pitkoff as a witness in this case. Kevin Whalen, the courier, is another person who I respectfully believe was in fact unknown to the people. And similarly, it would be measured and proper for the court to impose that sort of a sanction. Mark Partridge is the fifth of the names that I gave witness statements for yesterday, whom we do intend to call. But, Your Honor, when I reviewed my list this morning, I saw that there was a one-page statement of Mr. Partridge that was turned over in August. What I turned over yesterday was 2 additional pages. So therefore, they cannot complain to this court that they did not know Mr. Partridge and that they were not aware of what evidence he would offer in this case. So it would not be proper or fair to include him with the other 4 names. Ron Fishman, Your Honor, is a friend of Mr. Simpson. When we go down to lockup or go down to county jail and have conversations with Mr. Simpson, and we take notes during those conversations, and we'll ask him about what would Ron Fishman say, and Ron Fishman may make certain comments, or Mr. Simpson may make certain comments about what he believes Ron Fishman will say, or Joe Stellini will say, or Louis Marks will say. Your Honor, when we're thinking about calling witnesses weeks or months in advance, we do not have time to spend on limited resources, and they are in fact limited, for investigator time, and there are 2 investigators now only working on Mr. Simpson's behalf on a full-time basis to try to track down friendly, favorable witnesses whom we will not call for at least the next 2 months or so. And therefore, because we do not want to be sanctioned by preclusion, we then put their names on the witness list. And sometimes, Your Honor, we put the names on the witness list before we even have a copy of the address or the telephone number, because we expect reasonably and fairly that they will be called as witnesses, and that by the time it is relevant and necessary, we'll be able to provide continuing discovery, because it is, in fact, a continuing process. Your Honor, there are occasions when we've interviewed or spoken with, Mr. Cochran would speak to, for example, Henry Lee, Barbara Wolf, Michael Baden. These are individuals who are on their witness list. They are aware of the names. And I do not believe that the people have cited a case that argues that when a lawyer speaks to an expert about something that the lawyer may say in his opening statement, or about a proper response to the suggestions in the people's opening, that by that conversation alone, he is required to reduce that conversation to a discoverable document and then immediately turn it over to the other side. That is not the obligations, even under Prop 115, or the U.S. Constitution, or the California Constitution, Your Honor, because this man still has Fifth Amendment rights that still survive even Prop 115. Your Honor, they talk about not knowing about Dr. Carey Mullis, the Nobel Prize winner. I represent to the court that Dr. Mullis was a witness in the Wynn case, a case where Mr. Robert Blazier was the defense attorney in, a case with some of the same DNA issues, and a case where Mr. Blazier won and the court decided that DNA was not adequately reliable to be admitted in a criminal case. The district attorney's office is aware of that. And Your Honor, I believe that if Mr. Darden were to check with Mr. Woody Clark and Mr. Rock Harmon, he would learn that they have attempted to obtain Mr. Mullis's testimony in that particular case, that indeed Mr. Harmon sought to be introduced as a special district attorney in that case to help cross-examine some of the defendant's experts. So for them to say that, lo and behold, they didn't know, that they are surprised, I suggest to the court, is not totally with good faith.
Mr. Douglas, is Mr. Mullis on your witness list?
Your Honor, I've just looked for today, and he was on the list that we gave in October of complying back and forth with who our DNA experts are. He was not placed on our supplemental list, but he will. But that list, Your Honor, of DNA experts responded to their list of DNA experts. It was turned over to the district attorney. Mr. Clark, Mr. Harmon, and Ms. Khan are aware of each of them.
All right, was his CV exchanged in accordance with our agreement?
My understanding is, Your Honor, and Mr. Scheck is no longer here in court. Hopefully he's watching on a television with his family in New York City. But it's my understanding, Your Honor, that both sides have now mutually exchanged resumes of each of the DNA experts. But that's my understanding secondhand from Mr. Scheck. There's a suggestion, Your Honor, that Barbara Wolf was a surprise. Ms. Wolf's name, her address, her telephone number were provided in August of 1994. Again, we have conversations with Ms. Wolf. We do not reduce those conversations down in written form. There are no reports from Barbara Wolf concerning her testimony or her conclusions or her findings in this case. There are no reports from Dr. Michael Baden concerning his testimony, his conclusions, or findings in this case. There are no reports from Dr. Henry Lee, who is in fact the preeminent blood splatter expert in America concerning his conclusions, his findings, or his impressions in this case. We are aware if any such report is generated that it is discoverable, and we will do so. Your Honor, Mr. Weitzman is an attorney that Mr. Cochran has known for 30 years. I have enjoyed the pleasure of his company for 10, and I call him on the phone at home if I need to. When I say, Howie, tell me about what happened at the jail, and he says, they told me I had to leave, I do not think law or the code requires that I put that in a writing and turn it over to the other side. Skip Taft has been Mr. Simpson's personal business attorney for over 20 years. When he tells me that the police officers told him that they had to leave when Mr. Simpson was being interviewed, that is not a conversation that I would put down in writing. Whether or not the disclosure of the envelope was a proper function to present to the jury is not really a discovery issue, Your Honor. Is not really a discovery issue. That is properly a 402 issue. But remember, what happened was Mr. Hodgman stood up, Mr. Cochran walked over, told him what he's going to do, giving him the benefit of his information, allowing him to lodge an objection. It was lodged, sidebar was approached, the matter was resolved, and he moved on. There is some question about the statement of Dino Bucola. Your Honor, Mr. Bucola's name was given on Monday, and the court asked me, do you expect me to believe that there is no report? And I said yes, and there was no report. But on January 24th, in part because His Honor gave those words to me, I had my investigator interview Mr. Bucola. That interview took place on January 24th, and the document was faxed to our courtroom fax at 4:16 p.m. that day. When I received that document, Your Honor, rather than leaving the courtroom, I went upstairs myself to the 18th floor and handed that document to Sherry Lewis, making sure that I could do everything that I could in the face of the slings and arrows that were slung my way to show my good faith, to show that I'm trying to play fair, and to obviate any accusations that I heard this afternoon. The prejudice, Your Honor, that the people have suggested is just not true. Before 1992, Your Honor, there was no reciprocal discovery. Yet there were murder cases, there were robbery cases, there were shoplifting cases, there were drunk driving cases where the people would open up their entire file and the defendants would give absolutely nothing. So for these histrionics to go on and for there to be the suggestion that this is the most egregious wrong in the history of jurisprudence is laughable, clearly laughable. Only since 1992, when the people of this state, not the legislator, thought in their wisdom to impose on the defendants the requirements of Prop 51, have those requirements been in place, and defense lawyers in this state are continuing to wrestle with the implications of that law. We are continuing to weigh and to balance our obligations to a law that we feel is unjust and our primary obligations to our client who has an absolute right against self-incrimination. And Your Honor, if it means that we weigh in favor of self-incrimination and that those interests are more profound and those interests are the strongest, and as a result, we must be precluded from offering the testimony of those witnesses until the end of the defense case, so be it.
Mr. Douglas, as a former longtime federal public defender, this scheme of reciprocal discovery is not unknown to you, and it's well settled in the law given to us by the United States Supreme Court that these schemes are not unconstitutional.
Your Honor, I'm not arguing that the schemes are unconstitutional, but I argue that as a defense lawyer, I must constantly, daily wrestle with the internal conflict within me of resolving a law that I feel is unfair, a law that I feel is unjust, but a law that I'm compelled to follow. And there are conflicts, Your Honor, that are occurring across the defense offices in the state, in public defender offices everywhere. No one who represents a man accused of a crime, particularly a murder case, enjoys complying with that law, but we must and we try to. Your Honor, I recognize that it is not a constitutional issue solely. I recognize the wisdom of the courts. I do not argue that I should not or must not comply with the rule, even though I feel it unjust. And I do comply, Your Honor. But I offer to the court that when the court measures and balances and weighs everything, when the court does equity, which is indeed one of the most important roles of a judge, that a court balance the equity of the prejudice to the defendants and the real prejudice, not just the puffed up souffle of prejudice that we've heard this afternoon, but the real prejudice against reasonable solutions to a clear and understandable mistake.
Mr. Cochran? Good afternoon, counsel.
Good afternoon, Your Honor. Of all the lawyers who've addressed you, Your Honor, this afternoon, I'm going to try and be the shortest if I can. I'm sure you've been very patient, as always, and listened to us. I'm going to try not to raise my voice, Your Honor, because I think that it's important that we always try to conduct ourselves as professionals, even in the face of some rather untoward attacks. But I ask the court to remember that in the prosecution presentation, Mr. Darden, my good friend Mr. Darden, and I'm reminded that my wife is present in court here today, as the court knows, and during the break I introduced her to Chris Darden, and Chris says, I'm your husband's good friend, and I told my wife, I certainly hope that you don't love me like he does, because I think I might be in trouble. But I want to point out to the court that that with regard to Mr. Darden and some of these histrionics we've heard over the last couple of days, Mr. Darden is the same person who stood before you and told you that if we interrogated any police officer, like Mark Furman, with any racial slurs, it would so pollute, we could not pursue racial animus. It would so pollute this jury that they couldn't get a fair trial. Their whole case would fall apart. Remember that? You have to understand, put in perspective. They're the same people who brought you that, which is not going to be true, and I think everybody agrees with that. The counsel made a number of statements in their opening statement, and I think we should put things in perspective about opening statements, Your Honor. You have said on a number of occasions, and I said, we all said when we got up, opening statements are not evidence. What we expect to prove. What we expect to prove in good faith. If you don't prove that, then you suffer the slings and arrows that occurs with that. For them to stand here and talk about that they have suffered, there's an uneven playing field. Your Honor, for the first time in 7 months yesterday, somebody was able to get up and say something on behalf of Mr. Simpson. And that's all that took place. All I did was try to address what they had said, Your Honor. And
No,
with
objection, this is not relevant to the matter before this court, and Mr. Cochran has already
Ms.
addressed the
Clark,
court.
Ms. Clark, please, when we're here, outside of the presence of the jury, I'll hear the complete comment of counsel, please, without objection. You'll have an opportunity to respond to this. Mr. Cochran.
Thank you, Your Honor, again. With regard to this, I tried to address the things that they'd said in their opening statement, and I felt they said a number of outrageous things that they couldn't prove by any stretch of the imagination. But I didn't stand up. I didn't come crying to you that night and said, look, Judge, you know, he can't prove those things. He can't prove those things of domestic discord he talked about. That's not going to be, because we don't try cases that way, Judge. I'll just wait until I get my chance to tell the jury what I think, and then I will deal with the evidence. It's the evidence that we'll be talking about in this case. Now, certainly, for anyone to stand here and say that after 32 years of practice, that I would in any way jeopardize my reputation or do something untoward in a case, I would never do that. I would never, ever do that. What we're talking about here, and I wouldn't stand up as Ms. Clark did and tell the jury that Alan Park says he saw a Bronco parked there. I didn't jump on that. I just came back and read what he said. I don't have to call anybody a liar. I think in this case, that's the problem with them. They always want to label everybody. I would much prefer reading the testimony. And then I think it makes it clear. That's what I think we'll be doing or trying to do. Now, they make a big thing about all the things that I said. And it turns out, Judge, with regard to the things I talked about yesterday, that Dan Mandel and Ellen Aronson, very well known to them. They had all the reports. They talked to him. We had talked to him. Tom Lang, they talked to him. We had talked to him. As Mr. Douglas points out, Rosa Lopez, they talked to him. We had talked to him. Mr. Douglas has explained the situation with Marianne Gertjes, and I apologize to the court for that. Certainly, I thought that had been turned over. The last thing in my mind to try to do that. But I want to tell the court something about the responsibilities of counsel and why we need to be professional. During the break, we received a call in this courtroom from Marianne Gertjes' lawyer. She was so distraught. She is totally distraught at having been called a thief on television by Mr. Darden. He should be real happy that he made these statements within this courtroom. Her lawyers are incensed. This woman is very, very, very upset. She says it's absolutely untrue, and what she said is the truth. I mean, it's ironic and outrageous that they would do that. It seems to me, then, that whenever they stand up to talk, Judge, it has to be character assassination. Whether it's O.J. Simpson, whether it's Marianne Gertjes, whether it's at the end of this morning where he stands up and says, everybody on our list is a liar, a thief, or a felon. Isn't that interesting, Judge, that anybody that they don't call, becomes some very bad person? I don't think you conduct yourself that way, and I don't think that's appropriate when you talk about how we appear and how this system appears around the country. Now, more specifically, I've indicated to the court about Marianne Gertjes, and the court, Mr. Douglas has talked about Carrie Mullis. There's no confusion there. There's no confusion with the people regarding Cora and Ron Fishman. They know all these people because they all ran around together, Your Honor. And if it was inadvertent we left their name off, we apologize for that. I assume those names have been taken care of. My job has not been that aspect of it. I'm not trying to shy away from it, but everybody has responsibilities and roles, and so you can't do everything. But we want to adhere to that. Certainly, it's outrageous for anyone to say that we think we're above anything. I've practiced law in the courts of this county for 32 or 33 years. I am the blue-collar lawyer that he's talking about, except you see, I was on that side for almost half the time, and I've been out here earning a living the rest of the time. And so I understand both sides. I understand. Now, one of these days, when they get up enough nerve and come on this side, they'll understand, Judge, that it's tough when you have to run your own practice. You know, and Marcia was there for a short time. Yes, she was, to the credit, but not as long as we've been here. And she'd understand what Mr. Douglas was trying to say, and I want to clarify this as being a little older, maybe a little calmer at this point, that there is this philosophical thing, and I want to point it out to you, Your Honor. And the other day we had this conversation, we talked about defense lawyers and their role, and you said you've been a defense lawyer. When I go to the jail and I talk to my client, and he tells me something, I don't have any obligation to tell them that, Judge. If I know that he has rheumatoid arthritis, if I know that he had trouble shuffling cards on June 12th, there's no report on that, Judge. If, as Mr. Douglas says, if I talked to Howard Weitzman, whom I've known for 30 years, we represent Michael Jackson together. If I talk to him and I know what he and Skip Taft will say, there's no report on that. I don't think that you require us, in the midst of everything else, to sit down and write a report regarding that. Now, they know Howard Weitzman was down there. They know Skip Taft was there. This is no surprise, Judge. What happened, Judge, yesterday, and I want you to put this in perspective, was finally somebody from the defense had an opportunity to stand up and tell the facts as we understood them. If they don't like those facts, they say they feel is unfair. Judge, if we don't prove those facts, then they're all the better for it. They benefit from that. Nobody's trying to sandbag them. For months, they talked and tried this man in the press. They, talk about unclean hands, to vilify somebody like this man. And then even to stand here today, Your Honor, and refer to him as a dream defendant. Your Honor, who would ever want to be a defendant? That's if ever there was an oxymoron, Your Honor, that may be it, isn't it? A dream defendant? I mean, who wants to be a defendant? But that's to malign all of us. And we don't take it personally because Mr. Darden says he loves me. So since he loves me,
And I do.
I'm not going to take it personally. But Judge, go on and look at the rest of the list. Joe Stellini is a friend of the defendants. There's no report. We've not interviewed Joe Stellini. We don't have unlimited resources like they have, Your Honor. Michael Baden and Barbara Wolf came out here the week of these murders, if the court pleases. They went over, and there's a letter where Mr. Shapiro offered to help the LAPD and the coroner's office help solve this crime, which was rejected. They went over to the lab. They went over and looked at these exhibits. They know about them from the beginning, Judge. They were there like June 15th. They know about it. The one report from Henry Lee that you know about, we turned that over. I mean, we don't have any other reports. Now, I mean, I can't make, these are busy men. Henry Lee is the foremost blood splatter, crime scene, forensic expert in the country. And so they might not lack we have Henry Lee on the side, but that's not the reason to bar us. They know about it. Same thing with Carrie Mullis. If he wins the Nobel Peace Prize and they don't have him, they may not like that, but that doesn't level the playing field, Judge. They know about it.
I don't think he won the Peace Prize.
I said that. You know, Judge, I said that. I'm going to make that clear. The Nobel Prize for Chemistry. I had Dr. King on the mind yesterday when I was saying that, who did win the Nobel Peace Prize.
Linus Pauling won both. Never mind.
Yes,
Never
the only
mind.
one. No, you
Never.
would know those facts, too. I'm not surprised, Judge. You would. And, Judge, is he on our witness list yet? Okay. Well, if we put him on our list, then I'll let you know. If we put him on your list, Judge, I'll let you know.
If he appears, I'll be amazed.
Then you'll be amazed. Well, I think so, Judge. Your Honor, to continue on in a serious vein, so with regard to Michael Batten, Henry Lee, and Barbara Wolf, they're all out here the first week, Judge. What are they talking about? And there are no reports. I'm telling you, there are no reports. These are our experts. I don't have any reports. When we get reports, I will make sure, and Mr. Douglas will make sure that you get those reports. How about the envelope? I walked over to Your Honor's clerk, and I said, may I get this envelope earlier? And then I asked Mr. Douglas to get it. Before I finished doing anything, it was over here. I walked over to Mr. Hodgman, and I said, let me make an offer of proof to you. I'm not going to try to open this. What I was seeking to try to do, and you'll have to make the judgment on this, I'm a trial lawyer, and this is a court's exhibit, so it's not anything I had, and I was concerned about the chain of custody. And I made the offer of proof there. What I was seeking to try and do was use this as another example of the people's rush to judgment. Now, I know they wouldn't like me to use those words, Judge, but they can't stop me from using those words. And that was another example, as I tried to demonstrate with the fingernails and with the other things that they didn't bother checking up on. When Mr. Hodgman said, well, I'd like to approach the bench, we approached the bench. You, at first, you should recall, I'll tell you what you did, at first felt that it was appropriate. When you inquired further as to whether they had some report, which apparently Mr. Hodgman said they didn't have, which I didn't have either, and I thought they probably had it. You said, well, if they don't have that report, Mr. Cochran, you can't do it. And we put it back. Never talked about it. Now, that gets blown all out of proportions, and we still don't know until his speculation. He doesn't know what's in that envelope. Let me make that clear. I don't think he knows. If he does, that's something else that they know we don't, that they claim they don't know. But we've never said what's in that envelope. Never, and we didn't yesterday at all. The jurors don't know anything about that. So, with regard to this man's physical condition,